Hi, my name is Amber Rouse Holloway, and I'm a partner here at our Troy office. And today is the December 2021 episode of my PIP Monthly. Of course, we will have our case law update. Today I have two cases for you guys, Joshua Powell v. Progressive and State Farm v. Protective Insurance Company. Both of these are unpublished opinions issued by the Court of Appeals. And for trending topics in PIP litigation, we will discuss the case of Winfield v. State Auto. And this is a case that was represented by my office in both the trial court and the appeal. First up, we have the case of Joshua Powell and Phoenix Physical Therapy as the intervening plaintiff v. Progressive Michigan Insurance Company. Essentially, this case deals with the material misrepresentation on the original application for insurance and how that affects this case moving forward, given that the plaintiff in this matter sought benefits from the MACP and then attempted to collect a second time from Progressive. So by way of background, plaintiff appeals by right the trial court's error, granting summary disposition in favor of defendant on plaintiff's claim seeking PIP benefits under the No Fault Act. Plaintiff also, which this is important here, was seeking damages for fraudulent misrepresentation by Progressive, alleging that the fraudulent misrepresentation was by Progressive. On October 15, 2017, plaintiff was a passenger in a Ford Edge driven by his brother when it collided with another vehicle. Plaintiff suffered various injuries to his back, knee, elbows, and shoulders. Because plaintiff was not covered by his own no-fault insurance policy on the day of the accident, a claim for PIP benefits was filed with Progressive, the insurer of the vehicle driven by his brother. That policy for the brother covered a Ford Edge. It was first issued by Progressive in August of 2016 to plaintiff's brother and sister-in-law, who were the insureds. Covered the Ford Edge and another vehicle, and listed the address that the vehicles were being garaged at as an address in Inkster. However, throughout investigation of the claim, it was determined that plaintiff's brother actually lived in Detroit and the vehicles were garaged in Detroit and not in Inkster as indicated in the policy application. Thereafter, in December of 2017, defendant notified plaintiff's sister-in-law that it had discovered this material misrepresentation on the original application, that the vehicles were not being garaged in Inkster, and that the investigation had revealed that the 2016 Ford Edge listed on the policy was not garaged at the policy address at the time of the inception of the policy. 5 days later, defendant mailed 3 rescission notices to plaintiff's brother and sister-in-law stating that the policy was rescinded and considered null and void as of 12:01 a.m. on the day the policy started, August 18, 2016. And it said that the reason for this was because the insured person concealed, misrepresented, or made incorrect statements or representation regarding a material fact or circumstance, or engaged in fraudulent conduct in connection with the application. Defendant subsequently refunded all past premiums and payments in the amount of approximately $11,000. On January 2nd, 2018, defendant's adjuster called the Office of Plaintiff's Counsel, and so Plaintiff's Counsel, who is the insured's brother, Joshua Powell, advising that the policy had been rescinded and plaintiff's injuries were not covered by the policy. On January 4th, so 2 days later, the adjuster sent a letter addressed to plaintiff at his counsel's office, informing plaintiff that there was no valid coverage for the subject accident and that defendant would not pay plaintiff's claim. After the defendant denied the coverage, Joshua Powell sought PIP benefits through the MACP. And then in a letter dated January 25, 2018, the MACP informed plaintiff's counsel that plaintiff's claim had been assigned to another insurer. Thereafter, between March of 2018 and July of 2018, plaintiff executed several assignments to various providers, including Phoenix Physical Therapy. Plaintiff thereafter filed a first-party action against defendant Farmers, who was the insurer assigned by the MACP. Eventually, a facilitation was scheduled between the parties, and the case settled at facilitation, and Farmers' counsel informed defendant's counsel that the claims of 6 healthcare providers had also been settled in that facilitation. Then, on the same day the facilitation was completed, plaintiff filed his complaint against defendant Progressive. So here we have it. Plaintiff filed a PIP action against Farmers, who was assigned by the MACP, settles that in facilitation, and then the same day it settles, files against, for the same accident, files against defendant Progressive. Plaintiff in the lawsuit against Progressive also alleges that he suffered a serious and permanent bodily injury in the subject accident and that Progressive was now obligated to pay PIP benefits. Plaintiff further alleged that defendant had failed to pay the PIP benefits, and plaintiff amended its complaint to allege fraudulent misrepresentation by defendant, asserting that defendant had not rescinded the policy at the time of the accident and had misrepresented that the policy had been rescinded, had known that the representation was false when it made the representation, and made the misrepresentation with the intention that plaintiff would act upon it. And therefore, plaintiff claimed that it had suffered a damage or injury as a result. And as we have here in our slides, plaintiff asserting this fraudulent misrepresentation claim, and he alleges each of the 6 elements. In lieu of answering the plaintiff's complaint, Progressive filed a motion for summary disposition, arguing that the policy had been rescinded. Defendant further argued that plaintiff and his counsel had been notified of the policy rescission and argued that this action was an attempt by plaintiff to obtain a windfall. Essentially, in defendant's motion for summary disposition, it recounted each of these bullet points that we stated earlier, that it had mailed the rescission notices, that the adjuster sent a letter to plaintiff, that the adjuster called plaintiff's counsel and left a message advising that the policy had been rescinded. Ultimately, the trial court granted defendant's motion and dismissed plaintiff's complaint. Thereafter, this appeal followed. Plaintiff ultimately did not dispute any of the above facts that are discussed, but instead argued that defendant's rescission of the policy was not effective as to plaintiff under Bazzi v. Sentinel. In Bazzi, we all know that the Supreme Court held that the rescission of an insurance policy as to the insured is not automatically effective as to a third party. Here we have a third party as Joshua Powell, who is the brother of our insured. Essentially, the plaintiff here was indicating that the court needed to balance the equities as to Joshua Powell, and that it was Progressive's misrepresentation that the policy had been automatically rescinded as to Mr. Powell. Plaintiff's response to defendant's motion relied entirely on that argument that defendant fraudulently misrepresented that the policy had indeed been rescinded. Plaintiff goes on to state that defendant specifically committed fraud by deceptively stating that the policy had been rescinded. Again, plaintiff did not dispute any of the evidence that was presented in the trial court regarding the mailed rescission notices or the discussions between the parties, but instead states that the policy was not effective as to plaintiff under Bazzi. Ultimately, the court held that defendant's representations were not a misrepresentation, and that at the time the defendant rescinded the policy and denied coverage as to plaintiff, defendant was entitled under Michigan law to do so. The court goes on to argue that defendant's representations regarding rescission were not a misrepresentation, but that Bazzi number 2, was decided on July 18, 2018, 7 months after defendant informed plaintiff that the policy had been rescinded. At the time of the actual rescission of the policy, and at the time that defendant informed plaintiff's counsel of the lack of coverage, the court's decision in the Bazzi 1, the first Bazzi case, was binding precedent. In Bazzi 1, the court held that if an insurer is able to establish that a no-fault policy was obtained through fraud, it is entitled to declare the policy void and rescinded, including denying the payment of PIP benefits to innocent third parties. Bazzi 1 did not require a judicial determination to support rescission. So therefore, the court was not required to balance the equities as required under Bazzi 2. Moving on to State Farm Mutual Automobile Insurance Company, the Protective Insurance Company, which was issued December 21st, 2021. This case deals with a priority issue and the involvement of a motorcycle, and whether the involvement of a motorcycle would put the two insurance companies at the same priority level as to under the No Fault Act. By way of background, the case arises out of a collision in Lansing on October 27, 2014. Plaintiff insured a Buick LaCrosse that was being driven northbound. A motorcycle driven by a Robert Rader, whose PIP benefits are the subject of the action, was traveling eastbound. Rader ran the red light at the corner of Waverly Road, and his motorcycle struck the Buick LaCrosse at the intersection. He was thrown from the motorcycle, and his body collided with a third vehicle that was waiting at the light. The third vehicle was a FedEx van insured by defendant. Rader suffered injuries as a result of the accident, and plaintiff paid Rader's PIP benefits. So here we have State Farm paid the PIP benefits, and now State Farm is suing Protective Insurance Company, who is the insurer of the FedEx van that plaintiff collided with. Mr. Rader collided with. In August of 2019, plaintiff filed a complaint against defendant. Plaintiff asserted that it had paid over $1 million in PIP benefits to Rader because the vehicle insured by defendant was involved in the accident and shared the same priority level under the No Fault Act as plaintiff. Defendant is now liable to plaintiff for half of the PIP benefits it had paid. Defendant moved for summary disposition, contending that the insured van was not involved in the accident under the No Fault Act, and therefore it was not obligated to pay any portion of Rader's PIP benefits, and further that plaintiff's claim was barred by the statute of limitations and the doctrine of latches. Plaintiff responded that the FedEx van was involved in the accident because a victim's body contacted the van. The statute of limitations for recoupment is 6 years and therefore was not violated, and then the doctrine of latches did not apply. Plaintiff also moved for summary disposition in its favor and argued that the court should award cost, interest, and attorney's fees. After a October 2020 hearings on both of the parties' motions and cross motions, the trial court ruled that the FedEx van was indeed involved in the accident and defendant was liable for half of Rader's PIP benefits. Thus, this appeal followed. On appeal, defendant first argued that the trial court erred because defendant's vehicle, the FedEx van, was not involved in the accident under MCL 500-3114, Section 5. The court disagreed with that finding. The court disagreed with that argument. The court goes on to analyze MCL 500-3114, Section 5. It states that the subject to subsection 6 and 7, a person who suffers accidental bodily injury arising from a motor vehicle accident shall claim PIP benefits in the following order. A, or 1, the insurer or registrant of the motor vehicle accident. B, the insurer of the operator of the motor vehicle involved in the accident. C, the motor vehicle insurer of the operator of the motorcycle involved in the accident. And D, the motor vehicle insurer of the owner or registrant of the motorcycle involved in the accident. Obviously, MCL 500-3114, Section 5 is applicable when there is an accident between a motorcycle and a motor vehicle. Motorcycles are not required to maintain PIP coverage, while owners of motorcycles are required to do so. Despite the fact that the motorcyclists are not required to maintain PIP coverage, the No Fault Act nonetheless provides motorcyclists with the right to recover PIP benefits when they are involved in accidents with motor vehicles. The issue here is that the No Fault Act does not define what the term involved means or what it means to be involved in the accidents. So the parties here go on to dispute the appropriate test for whether a vehicle was involved in the accident, and likewise whether the FedEx van insured by defendant was involved in the accident under the No Fault Act. Plaintiff argues that the test for whether a vehicle was involved in the accident was simply whether a victim or his or her vehicle made contact with the vehicle, as stated in the case of Auto Club Insurance Association v. State Auto Mutual Insurance Association. Defendant, on the other hand, argues that the appropriate test for whether a vehicle was involved in the accident is whether its role was active rather than passive. And that's stated in the case of Bachman v. Progressive Casualty Insurance Company. The defendant went on to argue that the FedEx van was not involved in the accident because it was not an active contributor to the accident, that the van was passively stopped and waiting at a red light when it was hit by Rader's actual body. But again, defendant proffers the wrong test. Any consideration of active versus passive involvement, the court held, was not applicable to this specific case because Rader's body contacted the FedEx van, actually hit the FedEx van. Ultimately, the court noted that it had not directly addressed in a published opinion the issue of whether a vehicle is involved in an accident when a motorcycle is bodied, but not the motorcycle strikes the vehicle. However, the court noted in the case of Auto Club Insurance Association that there are no cases that actually suggest that a vehicle that actually collided with an injured person was not involved in the accident. Moreover, the court held that the analysis under the Turner case concerning active involvement is only required for liability. Taken together, regardless of a vehicle's fault in contributing to a collision or its lack of movement during an accident, a vehicle becomes involved in an accident when it is struck by a victim. So that is essentially what the court, what test the court applied. And given that test, it's apparent that the FedEx van was involved in the accident and defendant is liable or was liable for half of the PIP benefits that were previously paid to Mr. Rader. And last up, we have the case of Winfield v. State Auto Property and Casualty Insurance Company. In the case of Winfield, it's important to note that Secrets Wardle represented State Auto in both the trial court and on appeal. This case somewhat centers around the Covenant Medical Center v. State Farm Mutual Automobile Insurance Company, where the Supreme Court, as we all know, specifically endorsed the practice of no-fault claimants assigning their rights and signing these assignments. But after that, providers, as of June 11, 2019, providers no longer need assignments in order to sue for their services. MCL 500-3112 has since been amended since Covenant to allow healthcare providers to assert a direct cause of action against an insurer to recover overdue benefits payable for charges, services, or accommodations provided to an injured person. However, the practice of executing an assignment still remains common, and there are still plenty of suits and litigation involving pre-June 2019 services. So here, the case of Winfield, we have the issue of what happens when an injured person grants an assignment but still seeks payment for the same bill under their own no-fault suit. The relevant facts in Winfield are that before filing her complaint, plaintiff assigned her rights to various medical providers. She assigned her right to collect benefits from defendants. Essentially, each assignment vested in the medical providers the right to collect PIP benefits from defendants for medical services rendered to plaintiff and her minor children. There was no indication that plaintiff retained any power to revoke the assignments. Due to the same, all of the assignments that were previously executed before plaintiff filed her complaint were valid. As such, the assignments were valid, and the medical providers stood in the position of plaintiff, and they possessed the same rights as plaintiff and were subject to the same defenses as plaintiff. State Auto therefore moved for partial summary disposition of the bills that plaintiff had previously assigned before filing her complaint. The trial court denied the motion, and the Court of Appeals granted State Auto's interlocutory application and ultimately agreed with State Auto. Ultimately, the Court of Appeals held that after plaintiff executed the assignments, the medical providers became the real parties of interest, and only the medical providers had the ability to enforce their acquired rights. Therefore, State Auto was entitled to summary disposition as to those bills only, not the bills that plaintiff had not assigned or the bills that plaintiff assigned after she filed her complaint against State Auto. The court allowed plaintiff to seek recovery of the one bill that was assigned after she filed suit based on the reading of MCR 2.202B. If there is a change or transfer of interest, the action may be continued by or against the original party in his or her original capacity unless the court, on motion, supported by affidavit, directs that the person to whom the interest is transferred be substituted for or joined with the original party, or directs the original party be made a party in another capacity. Again, I'm not sure if I mentioned it previously, but this case is an unpublished Court of Appeals opinion. But although it's not presidentially binding, Whitfield does represent strong persuasive authority regarding the effect of assignments on standing in first-party no-fault litigation. And therefore, it's important to note when these assignments were executed and to, once a plaintiff and not a medical facility plaintiff files suit, those bills that were previously assigned can be stricken or taken away from the actual PIP suit by the injured party. Given the same in practice, it would be important to note all of the assignments and to note when the assignments were executed by the injured party to determine whether they should be excluded from instant actions of litigation. Again, thank you for attending the December 2021 episode of My PIP Monthly. My name is Amber Rouse Holloway. Please feel free to contact me with any questions or concerns you may have regarding this episode, and I look forward to talking to you guys next year.